David, would you please lead us in an understanding of the challenges to defining authors and authorship?
Good, yes. Let me start off by saying that if we wanted to address this issue sensibly, then Congress would tell us what its intent is about the terminability of sound recordings. Now, the only time Congress addressed that was in 1999, which it then took terrible pains to recant in 2000, as Jay told us. So that's a wash. Congress said something and then it retracted everything it said. What we're left with is a series of amendments that are inconsistent, that do not squarely address the issue, and basically put us in as uncomfortable a position as we can be in. Why is that? In 1965, a bill was cobbled together and universal agreement was given to it. That had the enumeration that Ann told you about, which did not include two very significant categories of works that are typically undertaken by a group of individuals. Those two categories are computer programs and sound recordings. It's obvious why they weren't included in 1965, because neither of them were subject to copyright protection. It's also obvious why Congress did not include computer programs in its enumeration when it passed the ultimate law 11 years later in 1976, because at that time, computer programs still were not subject to copyright protection. That didn't come until 1980. So the big question we're left with is, why, from that bill in 1965 until the time the law was passed in 1976, didn't someone add sound recordings? And the answer is because everyone was asleep. The bill was put to bed in 1965. It had an 11-year incubation when two controversial issues were worked out. Jukeboxes and cable television has nothing to do with the fact that sound recordings were added in 1971. So already we have the seeds of the disaster laid in 1976. Now, Jay mentioned to us the Blondie Parallel Lines album, which is a wonderful example. My colleague Peter Manel at Berkeley and I take that as a perfect illustration because the contracts, such as they were signed before the 1976 Act went into effect. They were signed in 1976 and 1977. Some of the tracks were laid down in that era. So if you look at those would be subject to termination 56 years later, and yet the album came out in 1978, so that's seemingly subject to termination 35 years later. So what do you do with such a mess? Well, the first question you have to ask, as Ann told you, is, does the work qualify on a basis other than sound recordings? You can't get it to qualify under sound recordings because that 1999 amendment was rescinded. So the first obvious candidate is a compilation. Now, you often hear a statement, on the one hand, every single sound recording is a specially commissioned work for hire. Or, on the other hand, 0 sound recordings qualifies as a work for hire. I'd like to reject both of those extremes. Here's an example of what I think could be a specially commissioned work for hire as a sound recording. Let's say Mark were to say, I want to get various people to re-record Beatles songs, and I'm going to hire Beyoncé to sing Yesterday, and Alicia Keys to sing Blackbird, and Eminem to do Why Don't We Do It in the Road. That would be an album that would be a compilation of pre-existing musical compositions, which in my estimation could qualify as a specially commissioned work. That is the type of compilation that Congress had in mind. What Congress had in mind classically is an encyclopedia where various individuals are hired to write an entry about France, about England, about Louis XIV, about Henry VIII. Okay, that would be a compilation that is not subject to termination. So this hypothetical album that I'm just making Mark the impresario of Beatles songs re-recorded by current stars, that would be a compilation that would be subject to that would not be subject to termination. It would be a specially commissioned work for hire. Now we ask Pink Floyd, The Wall, is that a compilation? Well, I guess one could argue on the surface it is a compilation. It strikes me that it is about as much a compilation as a novel published the same year, Gravity's Rainbow by Thomas Pynchon. Might be that Gravity's Rainbow contained 13 chapters. It might be that The Wall had 13 tracks on it. Neither of them is a compilation in the way anyone intended to use the term. Rather, Gravity's Rainbow is a continuous narrative broken down into chapters. Pink Floyd's The Wall is a continuous story broke up into tracks. And so I don't think that the reasonable interpretation is that either of those works would be a compilation as a specially commissioned work for hire. And once we determine that, that means that they both are subject to termination. So now we get into the realm of headaches. Who is it that is able to terminate Pink Floyd The Wall or Blondie Parallel Lines? Well, it's the authors. In the case of Thomas Pynchon, it's probably obvious that it's him and not his editor and not the person who wrote the blurb and not the person who took, well, you don't even have a photograph of Thomas Pynchon because he's a famous recluse, so there's no photograph.
There actually are 3 photographs, but they
There are 3
predate the book,
photographs?
yeah.
Okay, well, they're not on the
Days of
book.
Cornell, yeah.
Okay, so the question becomes, who can terminate Blondie's Parallel Lines? Well, I think at one point I analyzed it thoroughly. I think there were five performers in the band. But in addition to that, there are backup musicians, and there are vocalists, and there are sound engineers. And if Phil Spector had been involved with getting a wall of sound, there would have been a very serious record producer. But it wasn't Phil Spector, but it was somebody who was known at the time who did produce Blondie's Parallel Lines.
Mike Chapman?
Yeah, Mike Chapman, exactly.
Who was
right,
well
right.
known at the time.
Right, that's right. He was very, very well known. So the question becomes very simple in the case of a literary work, very difficult in the case of a sound recording. The only parallel you could look at is a motion picture, which also has 1 million people involved. That issue is solved. Congress said an audiovisual work is one of those 9 categories that Ann talked about, and every studio is extremely careful to get every single person to come on the set to sign a specially commissioned work for hire agreement, except for Mr. Al Muhammad, who I'll come to in a few moments. It's very difficult to know. In the abstract, it could be that Deborah Harry has the right to terminate. And let's say that she's earning 10% of the royalties right now, and she thinks, oh, that's 10% is pretty bad. I want to get 100%. So she starts to terminate. Then everyone else, Mike Chapman, the backup singers, the four colleagues, the studio musicians, the guys who are controlling the knobs, the record producer, they all get on the bandwagon. Now we have 20 notices of termination filed. So now Deborah Harry said, well, I used to get 10%. If all 20 of these are valid, I'm only going to get 5%. So I don't really like the way that things are hanging up. And it's probably the worst result we could think of. It's very bad for the record company. It's very bad for Deborah Harry. I guess it's a windfall for these backup vocalists. But it's probably a situation that no one would have intentionally gone into had they had their eyes open from the beginning.
And I just want to, I don't think the situation is that bad. I mean, nothing personal, but that's the argument that Hillary Rosen made in 1999 about the Parade of Horribles. And nothing personal, but I just wanted to go through a bunch of things.
So tell me why we immediately throw 19 of them out.
Well, okay, that's what I was going to get to. First, a variety.
Well, let's get to it now.
Okay, they have to contribute something of authorship.
Correct.
First of all.
Right.
And I don't think that everybody that you just listed actually did contribute something of authorship, and I think that the courts found that in the case that you mentioned, that, I can't pronounce his name.
Okay.
That wasn't actually a contribution of authorship. That's one. Another thing is I think a lot of these works, and this is where it's going to get even more complicated, are works of joint authorship where part of it is a work for hire capacity. I think a lot of these people do fall under the employee prong, or the first prong of work for hire, the session players and things like that. And then,
hang on. Let's just take them one at a time.
But David, stay organized.
The point about Al Muhammad is a point I want to get to. Before the Ninth Circuit ruled in a case involving the picture Malcolm X, it was always assumed that the record producers and the sound engineers and the backup musicians and pretty much everyone involved in a production who contributed to authorship is going to be a joint author. And absent an agreement among them, they all own an equal share. So Deborah Harry gets in, and she's the star. There's a backup bass guitarist who plays 3 licks. Each of them owns 50% unless they have a written agreement between themselves. But then there's the Al Muhammad case that we'll get to in a moment. So I would have said the background law is everyone has an equal share. But let's talk about what you raised, which is a fascinating point. You think that Deborah Harry had paid employees who worked 52 weeks per year as background guitarists?
No, but I think those guitarists were freelance employees, not independent contractors. I think, they were told where and when to report, what to do, very different. She provided the tools, she rented the studio, very different from what the featured artist does. I came from the union. I know taxes are withheld.
Okay,
They're paid very differently. But I think where that gets really interesting is what does that do to the terminability of the whole work? Now, I think, and this hasn't been decided, I think that the non-work for hire portion should still be terminable. Under the actual wording, and I had some interns, try and do this, and there are no cases, it says the termination right applies to any work other than a work for hire. Now, there is, a law student wrote an article that said that goes to an attribute of the work. So if any portion of a work is a work for hire, then nobody can terminate the non-work for hire portion of it. I don't think that's right, and I think that intent flies in the face of what Congress meant. But I think that's something that we do have to consider, because I think most of these works are joint authorship.
At the risk of committing suicide, by
I'll protect you from either.
by partially disagreeing with David Dimmer, the real problem is that every record is done differently. I represented for a very long time, you should pardon the expression, Phil Spector.
You still resemble him, sir.
Phil